I have 10:02 a.m. on December the 10th, 2013. It is my privilege to call to order the meeting of the Department of Commerce and Insurance Board of Funeral Directors and Embalmers. I would ask Ms. Lisa Mosby to call the roll, please.
Wayne Hinkle, Tony Highsmith,
Here.
David Neal,
Here.
W.T. Patterson, Jane Gray Sowell,
Here.
Robert Starkey,
Here.
Anita Taylor.
Here.
Mr. President, we have 5 out of the 7 is counted for.
Thank you, Ms. Mosby. We have a quorum present, and the meeting will continue as planned. If you will review the agenda as is presented on your iPads, please.
I move to adopt the agenda as presented.
Second.
Motion has been made by Mrs. Sowell, seconded by Mrs. Taylor to adopt the agenda as presented. All in favor, say aye.
Aye.
Any opposed? The agenda has been adopted. Ask board members now to please review the minutes from the December 12, 2013 meeting that is before you in hard copy. Give you a few minutes to look over that.
Make a motion, we adopt the minutes as written.
Second.
Motion has been made by Mr. Neal, seconded by Mr. Starkey to approve the minutes from the November 12, 2013 meeting. All in favor, say aye.
Aye.
Any opposed? Motion carries. Donna, are we ready for the presentation of the consent order?
Yes, sir, Mr. President.
The chair will now recognize General Counsel Benton McDonough to present a consent order.
Thank you, Mr. President. This consent order encompasses complaint number 2011-002691, complaint number 2012-000691, and complaint number 2012-000692. This matter comes before the Tennessee State Board of Funeral Directors and Embalmers based upon alleged violations found during routine inspections. The parties voluntarily enter into this consent order to avoid formal charges and a contested case proceeding with respect to the matters described herein. As for the stipulations of fact, case number 2011-002691, which involves an inspection that took place on January 11th, 2011. During that inspection, it was determined that the current license of the crematory used by this establishment was not available for inspection. Also, the latest inspection report of the crematory used was not available for inspection. Use of equipment and staff for a graveside service was not included on the general price list. The price for the limousine was not provided on the general price list. The low-end range for caskets on the casket price list was inconsistent with the low-end range for caskets on the general price list. The low-end range for outer burial containers on the outer burial container price list was inconsistent with the low-end range for outer burial containers on the general price list. The high-end range for direct cremation on the casket price list was inconsistent with the high-end range for direct cremation on the general price list. The type of container to be provided for direct cremation was not disclosed on the general price list. The price for direct cremation on the casket price list with an alternative container was inconsistent with the general price list. The brown alternative container listed on the casket price list for $295 was omitted from the general price list. Also, the display price of the, I believe it's the Agan copper 32-ounce CSR casket was higher than the price that was listed on the casket price list. Also, 4 caskets that involves the 20-gauge Blue Ocean Mist, the 18-gauge Coral Mist, the 20-gauge Brown, and the 18-gauge Black Perlin were offered in the casket selection room, but were not listed on the casket price list. Also, the ventilation fan in the preparation room was not in good working order, and a dressed and casketed body was lacking a permanent identification device. Next, the facts involving case number 2012000691 involving a inspection that took place on December 1st, 2011. The funeral director license of the establishment's manager was invalid. Scott Ham Jr., the establishment's manager, completed 4 contracts while acting on an expired license, including services for Gary Landon Randolph, Austin Wade Noble, Mary Odell Purdue, and Sowella G. O'Neill. Also, the ventilation fan in the preparation room was not working properly. Also, waste and soiled clothing were not properly disposed of, and the preparation room was disorderly and cluttered. Next, the cremation files for Gilbert Lee Tucker and Norman Bruce Burnell Caldwell Sr. did not have cremation authorization forms signed and dated. The establishment's website states that the manager's spouse, who is Catherine Ham, is a third-generation funeral director. However, she is not a licensed funeral director. Also, business cards for Ms. Ham were issued, lacking a notation regarding her specific title. Required disclosure language on the casket price list range was missing. Required disclosure language on the outer burial container price list was missing. The price for use of facilities and staff for memorial services was missing on the general price list. Also, the price for limousine was missing on the general price list. The price for immediate burial with cloth-covered casket on the casket price list was inconsistent with the general price list. The high-end range for outer burial containers on the general price list was inconsistent with the outer burial container price list. Also, the price for an alternative container was missing on the casket price list. The required disclosure language was missing on the outer burial container price list. The price of other preparation of body dressing, casketing, and cosmetizing was missing on the general price list. The price of other preparation of the body, autopsy, embalming, and donor embalming was missing from the general price list. And the price of staff, facilities, and or equipment for Saturday viewing was missing from the general price list. And no response was submitted to that particular complaint. As for the third complaint, which is case 2012000692, involving a inspection that took place on December 1st, 2011, Scott Ham Jr.'s funeral director and embalmer license expired October 31st, 2011, and had not been renewed at the time of inspection. Scott Ham Jr. completed 4 contracts while acting on an expired license, including services for Gary Landon Randolph, Austin Wade Noble, Mary Odell Purdue, and Sowella G. O'Neill. Scott Ham Jr.'s funeral directors and embalmers licenses were not available for inspection, and also Scott Ham Jr. failed to submit a response to the complaint in this matter. That concludes the stipulations of fact, and at this point, I will make the board aware of the agreed disposition agreed to by the parties. Number 1, respondents shall pay a civil penalty in the amount of $1,000. Each respondent shall be jointly and severally liable for payment of this civil penalty, which shall be received within 30 days of the approval by the board of this consent order.
Council, that's on page 8. We have,
Oh, I'm sorry. Yeah,
we've
yes, sir.
overlooked the stipulation of law, which we're all aware of, so we should now be on page 8.
Right. I'm
thank
sorry.
you.
My apologies. And actually, now we're on page 9. I'm sorry about that. Number 2, the funeral director license and embalmer license of Scott Ham Jr. shall become invalid and coded as surrendered upon acceptance by the board of this consent order. Number 3, the board shall not consider any application by Scott Ham Jr. for any license until the expiration of 5 years from the board's acceptance of this consent order. Number 4, the board shall seek no additional sanctions against Scott Ham Jr. or Portland Funeral Chapel by reason of the violations admitted herein. Number 5, Scott Ham Jr. and Portland Funeral Chapel understand and agree that the board's acceptance of this consent order shall extinguish any rights otherwise available pursuant to the Uniform Administrative Procedures Act, Tennessee Code Annotated Title 4, Chapter 5. And number 6, this consent order shall have no effect unless accepted by the board. Should this order not be accepted by the board, it is agreed that the presentation to and consideration of this consent order shall in no way prejudice Scott Ham Jr. or Portland Funeral Chapel or the state from further participation in either a formal or informal resolution of this matter. And it has been signed by Mr. Chick, also by Robbie Bell, who represents the respondents in this case, and also Scott Ham Jr.
Counsel, what was the original penalty that was assessed by the board at that time? Do we have access to that?
We do, but I don't have that on me at this time.
It would be somewhat consistent, I'm guessing, with the civil penalty here.
I would think so. Yes, sir.
And this agreed disposition in no way exempts them from future inspections or violations? I mean, this stands on its own
That's
as to
correct.
what happened at that time.
Everything that the only thing that is affected is anything that's encompassed in this consent order. So, if there are any violations in the future, that's separate from this agreed order. It just means that the board can't take further action if they decide to accept this consent order. The board can't take further action on these specific matters with these complaints.
But if anything else comes up, you can do that.
Right. Yes, ma'am.
That was my question.
I will also point out that this this involves 3 complaints, 2 of which are against the establishment and 1 against the individual.
Be nothing done to the establishment license, just his funeral director's license and embalmer's license.
That's correct. Did they sell? It's my understanding that this establishment is no longer owned by Mr. Ham. It's under new management.
Okay.
Did he ever renew his license from 2011?
I believe he did, because that would be the only way I believe that he could surrender his license, is if he had a valid license. So I think he did renew it, and as it states in the consent order, the license will be deemed surrendered once the board determines whether or not if they decide to accept the consent order.
Date of his signature to this consent is September
That's correct.
30th of 2013,
Yes, ma'am.
and it's taken this long to get it.
Well, there was an issue with a miscommunication between, I guess, with his attorney, that she was under the belief that she had provided these documents to us, and it wasn't till
No,
later that she
fine.
had actually done that. Yes, ma'am.
Board members, I'm sorry I was late. School closings kind of threw me off this morning, but this case is one that I had combined with a pre-need case that I had formal charges filed on, and we kind of worked on these as one settlement. I don't know if Are there any questions about it that I could answer?
For the record, that is Mr. Chick that is making additional comments in addition to what Mr. McDonough has made. And also, Ms. Mosby, if you will, let the record reflect that Mr. Hinkle has joined the board at the onset of the presentation of the consent order. Thank you. Any other questions for council or comments?
I move to accept the recommendation of council.
Second.
Motion has been made by Mrs. Sowell, seconded by Mr. Neal to accept the presentation of the consent order as it has been presented, to accept that order. Any further discussion? All in favor, say aye. Aye. Any opposed? Motion carries. Thank you, council. We'll now move into the emergency rules section of our agenda today. And Mr. McDonough, will you continue with the presentation of the emergency rules?
Yes, sir. Thank you, Mr. President. Good morning. My name is Benton McDonough, and I am the Assistant General Counsel for the Tennessee Department of Commerce and Insurance, Division of Regulatory Boards. Would the agency representatives who are present introduce themselves for the record?
Tony Highsmith, President, Fuel Director Board, Fuel Director and Bombers Board. Mr. Starkey.
Bob Starkey, member of the board.
David Neal, board member.
Wayne Hinkle, board member.
Anita Taylor, board member.
Jane Gray Sowell, board member.
Thank you. Today is Tuesday, December 10th, 2013, and the time is approximately 10:20 a.m. This review of emergency rules is taking place pursuant to Tennessee Code Annotated Section 4-5-208 in Conference Room 1-B of the Davy Crockett Tower, located at 500 James Robertson Parkway, Nashville, Tennessee. The purpose of this review is to present and adopt emergency rules regarding Public Chapter 437 of the Public Acts of 2013. A rule is defined as an agency statement of general applicability that implements or prescribes law or policy or describes the procedures or practice requirements of the agency. Emergency rules shall become effective immediately unless otherwise stated in the rule, upon a copy of that rule and a copy of the written statement of reasons for the rule being filed with the Secretary of State. The emergency rule may be effective for a period of not longer than 180 days. Mr. Robert Gribble, what notice was given to the affected individuals or groups?
Thursday, December 5, 2012, the agenda for the December 10, 2013 board meeting was posted to the Funeral Board's website indicating emergency rules pertaining to removal service registration under Public Chapter 437 of the Public Acts of 2013. On Monday, December 9, 2013, an email was sent to the representatives of the Tennessee Funeral Directors Association, the Tennessee State Funeral Director and Morticians Association, and the Cemetery Association of Tennessee. Also on Monday, December 9, 2013, pursuant to Tennessee Code Annotated 4-3-1306D, notice was sent to all interested parties who signed up to receive notice of changes pertaining to the funeral board.
Mr. President, according to Tennessee Code Annotated 4-5-208A, an agency may, upon stating its reasons in writing for making such findings, proceed without prior notice or hearing to adopt an emergency rule if the agency finds that 1. An immediate danger to the public health safety, or welfare exist, and that the nature of this danger is such that the use of any other form of rulemaking authorized by this chapter would not adequately protect the public. The rule only delays the effective date of another rule that is not yet effective. 3, it is required by the Constitution or court order. 4, it is required by an agency of the federal government, and adoption of the rule through ordinary rulemaking procedures described in this chapter might jeopardize the loss of a federal program or fund. Or 5, the agency is required by an enactment of the General Assembly to implement rules within a prescribed period of time that precludes utilization of rulemaking procedures described elsewhere in this chapter for promulgation of permanent rules. Mr. President, due to the General Assembly enacting legislation pertaining to removal service registration under Public Chapter 437 of the Public Acts of 2013, with an effective date of January 1st, 2014, the board should now make a determination of its reason or reasons for holding such review of emergency rules.
Having heard that, the board will entertain a motion that we move forward with enacting emergency rules to deal with the title that Assistant Counsel has read to us today.
So moved.
Second.
Motion has been made by Mrs. Sowell, seconded by Mr. Neal, to move forward with the emergency rule making hearing and enact those rules today.
And I'm sorry, and if we could make sure by a motion through the board that the specific reason for that, the statute sets out the five options for the board to determine what's the proper course of action, and I think it would be proper just to make sure that the board adopts one of the five factors.
So, can you include that in your motion?
Yes, I will. Would you give me the wording you feel is necessary for the motion?
Yes, ma'am. I think based upon factor number 5, that the agency is required by an enactment of the General Assembly to implement rules within a prescribed period of time that precludes utilization of rulemaking procedures described elsewhere in this chapter for the promulgation of permanent rules. Based upon that factor, it would be appropriate for the board to move forward with the rulemaking process.
The court reporter, do you have that? And can put that in my motion, please? Make that my motion.
That, as long as it's recorded, I think is sufficient.
Thank you.
With Mrs. Sowell's addition to her motion, Mr. Neal, does your second stand?
Yes.
Is there any other discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries.
At this time, I will read the substance of the proposed rule into the record. New rules under Chapter 0660-03, fees, 0660-03-.011, removal services. Under subsection 1, an application for registration as a removal service shall be submitted on a form prescribed by the board and shall be accompanied by a non-refundable fee in the amount of $350. Subsection 2, the board may renew a certificate of registration provided that an application for renewal accompanied by a non-refundable fee in the amount of $250 is received by the board no later than the date of expiration. Chapter 0660-12, removal services, 0660-12-.01, removal services. Subsection 1, no removal service as defined in TCA Title 62, Chapter 5, Part 1, shall operate in this state without first registering with the funeral board as a removal service. An application for registration as a removal service shall be submitted on a form prescribed by the board and shall be accompanied by a non-refundable fee as set by the board and proof of liability insurance with minimum $1 million in coverage. Subsection 3, the board may renew a certificate of registration provided that an application for renewal accompanied by a non-refundable fee set by the board and proof of liability insurance with a minimum $1 million in coverage is received by the board no later than the date of expiration. Based upon,
These are the recommendations, as you may remember, that came out of our work session, I believe in October, is that correct?
I believe so, September, October.
You may remember those being what came out of that work session, okay.
Based upon this reading of the proposed rules, at this point, it would be proper for the board to take a roll call vote on the record.
We need a motion to adopt these rules or take a roll call vote on the rules?
I think we could do a motion and then go through and do a roll call.
The rules have been read, and they are before you electronically for your review. That will go into effect January 1, 2014, and will be in effect for 180 days, is my understanding.
That's correct.
Okay. Having reviewed those, the board will entertain a motion for those recommendations to become rules.
Make a recommendation that these become rules.
Second.
Motion has been made by Mr. Starkey, seconded by Mr. Hinkle, that these rules shall be adopted by this board. Is there any further discussion? Ms. Mosley, will you call the roll, please?
Wayne Hinkle,
Yes.
Tony Highsmith,
Yes.
David Neal,
Yes.
Jane Grey Sal,
Yes.
Robert Starkey,
Yes?
Anita Taylor.
Yes.
Mr. President, we have 6 yeses.
Motion carries. Thank you.
At this time, the board shall make a declarative statement as to whether or not those emergency rules have any sort of projected impact on local governments.
Mr. McDonald, will you give further instruction regarding that, please?
Yes, sir. Based upon the current rules that have been adopted by the board, it's our recommendation that these rules will not have much, if any, impact on local governments.
That same statement needs to be entered in the form of a motion
Yes, sir.
by a board member, please.
Mr. Chairman, I move that it's a consensus of the board that these actions regarding the removal service will have no impact on local or any other government.
Second.
Motion has been made by Mrs. Sowell, as has been recorded, seconded by Mr. Hinkle. Is there any further discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries.
Mr. President, and this concludes the review of emergency rules.
I ask the court reporter, does that conclude your involvement in our meeting, or will? Yes, sir. Okay, do you have any other questions or comments for us? Okay, thank you for your participation today.
I'm sorry. Let me. I just need to add one more thing. I'm sorry about
Oh,
that.
I'm sorry. Go ahead.
Sorry. We also would like motion from the board that gives us the authority to move forward with the official full rulemaking process with these adopted rules.
Make a motion, we'll move forward.
Second.
Motion has been made by Mr. Neal, seconded by Mr. Hinkle for the legal department to move forward with the enaction of these rules. All in favor, say aye. Aye. Any opposed? Motion carries.
Thank you. This concludes the rulemaking hearing at this point.
Next item on our agenda is proposed rules discussion of military applications. Chair again recognizes Assistant General Counsel Benton McDonald.
Thank you, Mr. President. This law involves public chapter number 122, which includes Senate Bill 493 and House Bill 422. In this matter, the bill establishes demands that the boards establish procedure to expedite issuance of license certification or permits to individuals who are certified or licensed in another state whose spouse is a member of the armed forces, whose spouse is transferred by military to this state, and the individual left employment to accompany the spouse to Tennessee, or the individual is a member of the armed forces and carries a current license or certification in another state to perform substantially similar services in the other state, and the individual applies for a license in Tennessee within 180 days of retiring from the armed forces, receiving any discharge other than dishonorable discharge, or is released from active duty into reserve component of the armed forces. Furthermore, the board shall, upon application, accept military education, training, or experience completed by the person toward qualifications to receive license or certification if such is determined substantially equivalent to standards of the state. Furthermore, if the registrant or licensee is called to active duty and license or registration expires during the period of activation, then the license or registration shall be eligible for renewal without payment of late fees and penalties. Also, they are not required to obtain continuing education if active duty prevented them from obtaining such a waiver request. I'm sorry, from obtaining the continuing education, as long as a waiver request is submitted by that individual or the person performs the same occupation as part of their military duty. And such renewal shall be valid for 6 months from the person's release from active duty, and the person shall provide supporting documentation evidencing activation prior to renewal, and the board shall promulgate rules and regulations to enforce this act. And so basically what we wanted to do is make you all aware of that law that's in place, and the fact that we need to work towards a rulemaking process for carrying out this particular law. And the purpose of bringing it up today is just to let you know that it's something that will be coming up in the next few board meetings as far as the rulemaking process. And I guess.
It's my understanding and my that our office works as expeditiously as possible regarding all applications. We have had opportunity, the office is aware of this request that has been handed down, and I don't necessarily see any action that needs to be taken by this board today, that just continue for the office staff to operate as expeditiously as possible regarding all applications. Any other discussion? John, are you now prepared to enter into the legal report, or do you need a break?
If you all are ready, I can enter into
ready?
I can do that. That's not a problem.
Just a second for everybody to pull their legal report up. Everybody on page? Okay, counsel, if you'll continue.
Thank you, Mr. President. The first complaint is complaint number 2013-019-011. The complainant contacted respondent regarding a full refund of $9,386.86 from a funeral bill on October 13th, 2011. The complainant states that it was not an irrevocable contract and the owner has died and the complainant will not be using the establishment services. The complainant states that they were told that they would receive a credit in return rather than a full refund. In response, the board received a letter on November 27th, 2013 from the son of the deceased establishment owner stating that the establishment was now closed. As far as a complaint history, we found numerous previous complaints, and at this point, we're recommending that this complaint be closed as the establishment is no longer in operation.
Counsel, would the complainant have recourse in another avenue?
Court of law.
Yes, yes, sir, yes, ma'am. They would be able to probably seek a refund from the establishment, maybe through the
Civil action.
estate of the previous owner, I would think. But there's nothing that the board could do to provide her with a refund at this point, anyway.
Accept council's recommendation.
Second.
Motion has been made by Mrs. Taylor, seconded by Mr. Hinkle to accept council's recommendation to close the complaint. Any further discussion? All in favor say aye.
Aye.
Any opposed? Motion carries.
I have a question, not concerning this, but kind of concerning this. Are there any rules in place that, in other words, if an establishment closes, kind of like an insurance company goes out of business and somebody has to take over, or they have to give their pre-need trust accounts and what have you, somebody takes that over? Is there anything that protects the public there in place?
I don't know of any rules that we specifically have that address that issue. I mean, if it's
An insurance goes out, then somebody goes in a pool and somebody has to take it over.
Right.
So it kind of protects the public. I was just curious after this, I mean, generally the money should be in trusts, so I mean, it should be in a separate account, whether it be in an insurance product or, so the family really shouldn't have access to it, even though the funeral home, the family should have access to it, even though the funeral establishment closed.
That's probably something that they can address with private counsel, and in that case, if they wanted to challenge the estate of the deceased owner in this case.
But if the money is in an irrevocable trust, it is still there.
Right.
correct? And that money can be used when the individual the contract was
They,
put
they,
in place for dies, then they can,
they
the
should be
money's
able to
still available.
transfer to another
So,
funeral
I mean,
establishment.
there's not, they haven't lost their money, their
Right.
investment.
Number 2 is case 2013019571. The complainant stated that the respondent continues to run an advertisement in the local newspaper with the complainant's name listed as the Director of Community Affairs, licensed funeral director and embalmer. The complainant has not been employed there since October of 2012, and the complainant has spoken with the COO regarding this issue, but the matter has yet to be resolved. In response, the respondent states that this complaint is the result of a small church advertisement, which was not removed from print once the complainant left employment with the respondent. The respondent notified the newspaper in April about removing the advertisement, but the complainant called the respondent again in August to state that the advertisement was still running. On August 5th of 2013, the respondent sent a new advertisement to replace the old one. However, the newspaper continued running the old advertisement. The respondent determined that the church advertisements were overseen by an outside third party who was slow to respond. However, they have since contacted the third party as of October 22nd of 2013, and the misleading advertisement is no longer running in the paper. We found a history of 2 closed complaints in this matter, and we're recommending that this matter also be closed.
Motion to accept council's recommendation.
Second.
Motion made by Mr. Hinkle, seconded by Mr. Starkey to accept council's recommendations. Any further discussion? All in favor say aye.
Aye.
Any opposed? Motion carries.
Number 3 is case 2013019591. The respondent's billboard is advertising affordable funeral packages for $2,995. The respondent, however, failed to provide an itemized listing of what services and/or merchandise is included in the package. The respondent states that the respondent provided a photograph of the sign, which includes an itemized listing of the merchandise and services included in the price of the package. Respondent states that their attorney and the sign company reviewed the sign and found it to be in compliance with state law, including the minimum size of the font required for disclaimers. On a side note, while it was evident that the respondent provided an itemized listing of the merchandise and services included in the price of the package, the print is of such a small stature that it would be difficult, if not impossible, for any consumer to fully realize the merchandise and services included in the package. We found no history of prior complaints, and we're recommending a consent order with a $500 civil penalty and authorization for a hearing.
Make a recommendation to accept council's.
Second.
Motion made by Mr. Starkey, seconded by Mr. Neal to accept council's recommendation. Is there any further discussion? All in favor say aye.
Aye.
Any opposed? Motion carries.
Number 4 is case 2013019641. The complainant believes that the respondent is advertising discounts for at-need services. The complainant provided an advertisement that provides the total at-need discount of $1,500. In response, the respondent states that they are aware of the law prohibiting pre-need discounts. However, they are not a pre-need seller and are not aware of any law or prohibition against offering at-need discounts. In this case, we found a history of 1 open complaint, and we're recommending that this case be dismissed.
Motion to accept council's recommendation.
Second.
Motion made by Mrs. Taylor, seconded by Mr. Hinkle to accept council's recommendation to dismiss. Any further discussion?
I have a question about how you offer sale. And somebody, if they die 10 years from now, they're gonna get a discount?
don't believe it would be in this. That would be a pre-need discount. This is an at-need discount.
But they're offering at-need discounts. Is that what that says?
That's correct.
They're saying, okay, if you die next week, I'm gonna give you a $1,500 discount. Making the statement in advance of the death.
The person's coming in
I'm
and
not trying to be
and-
trivial or anything. I mean, it's just a scam like all this other stuff. Excuse me. Spinning. Doing it in advance of the death. They're saying that they will do that. So that's pre-need.
Well, if the customer went in there though, sorry, if the customer went in there, they could not offer the discounted price if the death had not occurred. So, in that sense, even though they're advertising it, it still would be at need, or they shouldn't be given the discount.
Any other discussion? We have a motion on the floor that has been seconded. All in favor, say aye.
Aye.
Any opposed?
No.
Motion carries, and let the record reflect that Ms. Sowell votes against the motion. Thank you, Ms. Mosley.
Number 5 is case 2013020151. On or about September 13th, 2013, a field representative conducted a routine inspection of the respondent establishment. The corporation owning the respondent owns location A and location B. However, location A has had an expired license for several years. Despite having an expired establishment license and not currently operating, location A has an active listing in the Yellow Pages. Anytime a consumer tries to contact location A based upon the listing in the phone book, the phone is then forwarded to the respondent establishment at location B. Additionally, during this inspection, the current inspection report for the crematory utilized by this establishment was not available for inspection. In response, the respondent states that this incorrect phone listing is not defined as an unfair or deceptive act or practice. The Yellow Pages listing was not intended to be misleading. Location A was closed, but the respondent forwarded the phone line to location B so that anyone with a pre-need contract with location A can find their paperwork and determine their funeral options. The respondent's attorney contacted the phone company to change the Yellow Pages listing prior to the next edition being distributed. As for the lacking inspection report, the respondent felt it appropriate to keep a copy of the latest inspection report at the corporate headquarters. Therefore, there was no crematory inspection report available at the respondent location because those documents were kept at the corporate headquarters. In this case, we found a history of 2 closed complaints, and in this case, we're recommending a letter of warning.
Okay for the inspection reports to be kept at the headquarters, corporate headquarters?
We don't believe so, no, sir. We're just making them aware that from this point forward, they need to be kept at the actual establishment location and not at the corporate headquarters.
Are they a part of an umbrella corporation?
I know that there is a corporation that owns, I believe it's just those 2 establishments.
Where's the corporate headquarters if it's not in location B?
It's
Location A is closed.
it's located in the same city, but it's not at the location there, location B. It's a separate location.
So this is a violation, but you're just wanting to do a letter of warning?
Right, because they
No civil penalty for it?
They did have the inspection report and a copy of the inspection report and the license, but they just didn't have it at the correct location. And so at this point, we're willing to recommend a letter of warning, but if it happens again, and they've at this point have been made aware that it needs to be at the location at the establishment, then we'll probably go for something stronger.
Motion to accept council's recommendation.
Second.
Motion made by Mr. Hinkle, seconded by Mr. Starkey to accept council's recommendation of letter of warning. Any further discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries.
6 is case 2013021-881. The complainant's daughter passed away following an auto accident and had services conducted in Mississippi and later at the respondent's funeral establishment in Tennessee. The decedent was to have the first service in Mississippi and then a day later to transport the decedent's body to the respondent's funeral establishment for services and cremation. Upon seeing his daughter's body once it was brought back to Tennessee, the complainant states that he was not satisfied with the daughter's condition as her makeup was terrible and the flowers had wilted. Furthermore, the complainant states that he was provided changing prices for the services, but finally agreed to the final price of $900. The decedent passed away on August 24th, 2013. The first service was in Mississippi on August 29th, 2013. And the funeral service in Tennessee was scheduled for September 1st, 2013. And the complainant states that the respondent failed to file for a cremation permit until September 6th of 2013. The complainant states that the funeral director told the family that he would obtain the permit no later than September 4th. The complainant called the respondent on many occasions. Once the respondent informed him that he was having difficulty obtaining the permit and that this happens a lot with this particular medical examiner's office, but several times the respondent failed to answer the phone or return phone calls. The complainant contacted the medical examiner's office and determined that the respondent never filed the paperwork for a cremation permit until September 6th of 2013. The complainant believes that the respondent lied to him and at the time when the complainant and his wife were at their most vulnerable. In response, the respondent states that the complainant's recollections are inaccurate. The respondent told the family that given it was close to the Labor Day holiday, that they should be able to obtain a cremation permit no later than Wednesday, September 4th. The complainant informed the respondent that they would hold a graveside service on September 7th or 8th, and that this was the only deadline given to the respondent. The respondent states that he never told the complainant that they were having a tough time getting a permit from the medical examiner's office, nor did the respondent say that this is a regular occurrence with this particular medical examiner, as this was the first time that they ever did business with this particular county. Furthermore, the respondent states that they provided the cremains in a timely fashion for the graveside services. We found a history of 4 closed complaints in this matter, and we are recommending that this case be dismissed.
Make a motion, we accept council's recommendation.
Second.
Motion made by Mr. Starkey, seconded by Mrs. Taylor to accept council's recommendation to dismiss. Any further discussion? All in favor say aye.
Aye.
Any opposed? Motion carries.
Number 7 is case 2013021-891. The complainant's brother passed away in August of 2013. The decedent was an employee of the respondent funeral establishment, and complainant's funeral bill was allegedly covered by the funeral establishment due to the decedent's employment with that establishment. However, the complainant later received a bill for the funeral services for $9,177.54. During the period of visitation and services, the complainant informed the respondent that they wanted a new casket, as the current one was actually the display model and it had a crack in the center of it. But the respondent asked why the complainant had such a problem with it when they were not the ones actually paying for the services. The complainant also states that the respondent worked with the decedent to have his life insurance policy changed to the name of the funeral establishment as the beneficiary of 50% of the policy. The complainant states that they were led to believe that the insurance policy was no longer enforced, as the decedent had not worked since being diagnosed with stage 4 cancer in 2012. The complainant was upset that a car was sent to the home of the decedent's girlfriend, who also worked at the funeral establishment, and that the car was not sent to the decedent's next of kin. Furthermore, the complainant believes that the flowers should have been given to the next of kin instead of the decedent's girlfriend. And the complainants did not say much about these issues at the time because they were under the impression that the respondent was covering the funeral costs. We received no response from the respondent in this case, and we found a history of 9 closed complaints. And we're recommending a consent order with a $1,250 civil penalty, which includes no response from the respondent and authorization for hearing.
Motion to accept council's recommendation.
Second.
Motion made by Mr. Hinkle, seconded by Mr. Neal to accept council's recommendation. Any further discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries.
Number 8 is case 2013022261. On October 1st, 2013, a field representative conducted a routine inspection of the respondent establishment. This establishment is a crematory, but is operated under the same establishment license as its funeral home. During the inspection, 8 crematory files failed to contain a signature of the person who received the decedent on behalf of the crematory facility. Also, one decedent's file failed to contain the date of release, time of release, and signature of the person who released the cremated remains. And another file failed to contain a release of cremated remains form. Also, one cremation authorization form failed to contain the signature of a licensed funeral director. In response, respondent states that the person who delivered the decedent to the crematory was the same person receiving the decedent on behalf of the funeral establishment. Respondent believed it was unnecessary to sign the receipt twice in this case, and this matter has been corrected for future notice. Also, this information was, as for the missing information on the release of cremated remains, respondent states that this information was written in a release log in the office, but not noted on the receipt before it was placed in the file. Also, a new oversight plan was put in place to review all files before they were permanently filed away. As for the missing signature of a licensed funeral director, the respondent states that this authorization was delivered by the outside funeral home by the licensed funeral director of that firm. Also, the crematory operator assumed the signature was affixed and simply failed to review the documentation. And respondent states that this human error has been addressed with a reminder that all documents must be carefully reviewed before filing them. We found a history of 11 closed complaints in this case, and we're recommending a consent order with a $500 civil penalty and authorization for a hearing.
Motion to accept council's recommendation.
Second.
Motion is made by Mr. Hinkle, seconded by Mrs. Taylor to accept council's recommendation. Any further discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries. Chair will now recognize Mr. Robert Gribble, Executive Director, for administrative matters.
Thank you, Mr. President. First is the licensee report, which is a report of licenses administratively approved by the Executive Director pursuant to the Board authority for the period of November the 12th, 2013 through December 9, 2013. And before you have a list of those individuals: Jeffrey Darrell Davenport, Baxter, Tennessee Funeral Director and Embalmer; Bradford Lee Farmer, Memphis, Tennessee Funeral Director and Embalmer; Tately K. Jennings, Columbia, Tennessee Funeral Director and Embalmer; Leah Faye Brooke Steedham, Wartburg, Tennessee Funeral Director and Embalmer; Bradley Eugene Filden, New Market, Tennessee Funeral Director; and Stephen Walter Howard of Bristol, Tennessee Funeral Director for reciprocity. Next, you have the closed establishment report. There are 2 establishments that are reported closing since the last board meeting. The first one is Wise Choice Cremations, located at 2735 Highway 64, Suite 104 in Hickory, Wythe, Tennessee, and Holmes Funeral Home, 1408 Joe Johnston Avenue here in Nashville, Tennessee. Next is a disciplinary action report. This is a report of the consent orders administratively accepted or approved by the Executive Director pursuant to the Board authority for the period of November 1, 2013 through November 30, 2013. You have a list of those different consent orders and amount of civil penalties. Those were just routine consent orders, is what the board had previously authorized. And last for my report is the open complaint report. The number of complaints open as of December 9, 2013 was 116, 0 against apprentices, 9 against either funeral director or embalmers, and 107 against establishments.
May I ask you a question regarding
ma'am.
the disciplinary action? The respondent Neptune Society of Brentwood, which was issued an establishment license, was it?
It's probably been,
I mean,
they've probably had a license for over
Do
a
they
year.
now have a licensed individual?
Do they have a licensed individual
Yeah.
as a manager? Is that your question?
Yes.
Yes. J. Dan Buckner is their manager.
Okay, of the Neptune Society in Brentwood.
Yes, ma'am.
Okay.
President, that concludes my report. If there are any other questions, I'll be glad to answer those.
I will entertain a motion to accept Mr. Gribble's report on administrative matters.
Make a motion, we accept.
Second.
Motion made by Mr. Neal, seconded by Mr. Tinkle to accept Mr. Gribble's Executive Director report on administrative matters. All in favor, say aye.
Aye.
Any opposed? Motion carries. Gribble, the next item on our agenda is apparently some individuals that wish to appear before the board regarding quarterly reports of apprentice training. Is that correct?
That is correct. The first one is Caleb Andrew Lynch, who is an apprentice, and his sponsor, which is Mr. Benjamin John Gamble, who is a funeral director and embalmer sponsor. If you will, gentlemen, just move up to the seats there, kindly pull a microphone toward you, and if you're talking
On
okay.
page 11.
Oh, if you're talking okay, then the red light will be on. Let me kindly give the board some information, if that's okay, Mr. President.
Yes, sir.
Within a period of less than a week, we had 3 situations to come up regarding apprentices and the quarterly reports. That's routinely and consistently we have that situation to come up, but normally not that many in that short a period of time. So we handle these according to the established policy and procedures as we've been directed by the board. But then some additional questions came up, and we thought it was best to bring these matters to the board for the board to make a decision. I will kindly inform the board about the first one, and then you gentlemen will have every opportunity you want to say whatever you want to say, and if I misstate something, well, you feel free to point that out. The first one before the board today is Mr. Lynch. He was approved on August 30th, 2011 as an apprentice funeral director and apprentice embalmer with an effective date of August 25, 2011. He turned all of his reports in on time, and there wasn't any problem till sometime probably 6 weeks ago or less. Mr. Gamble called me one day and he said, I've talked to some people in your office and you don't have a quarterly report for Caleb Leach for July through September 2012. And we looked and we did not have that, and we talked, Mr. Gamble and I talked about it, and he said that he would talk with his dad, and if either his dad or he or Mr. Lynch, one might want to appear before the board. So I asked Mr. Gamble if they had a copy of the report, and he said that they did. And I asked him to fax that to me, and he did, and we received that on November the 26th, which it shows the report was completed on October the 10th, 2012, and the cases are listed there in front of you. As I told Mr. Gamble at the time, I am not saying that the report wasn't mailed, because, it could have been. I'm not at all indicating that it wasn't mailed. We just do not have it in his file in our office. And to show you how serious, and I've talked to Mr. Gamble about this, as to how serious we took the matter, We have 4 administrative assistants that worked, that actually pulled every apprentice file. We have probably in excess of 500 apprentice folders. And so actually pulled each one of those files and went through every page, of every piece of paper in that file. We did not locate his report. We did find 3 other reports which had been misfiled because we thought that was a possibility, that we'd misfiled it in the wrong one. Back earlier, we did a smaller search and didn't locate anything, so later we did the complete search of all the files. So with that being said, if that's all I have to set the stage, Mr. Highsmith, if you have other questions later during the process, I'll be glad to answer those as best I can.
Get the facts straight. When is the apprenticeship actually being served for? What's the beginning date of the apprenticeship?
The apprenticeship, the beginning date was August 25, 2011.
And the first quarter of that apprenticeship would be what months?
Yeah, it'd be July through September of 2011 would have been the first report that was received, and that report July through September 2011, it was received November the 30th, 2011. The next report was for October through December 2011. It was received January 18, 2012. Next report was January through March of 2012, and it was received on April the 30th, 2012. The next report was for April through June 2012, and it was received July the 23rd, 2012. And the last report's the one that's in question here today.
August, September, and October of 2012 is the one that's in question, correct?
July, August, and September.
Send it by certified mail.
No, ma'am, I did not.
And how many quarters of apprenticeship are required?
It's my understanding, and Mr. Lynch can expand upon this, but it's my understanding that he either has or is about to receive an associate's degree from John A. Gupton College here in Nashville. So with that level of education, he would be required to have 1 year of apprenticeship, which would be 4 quarters. If he were only getting a funeral director's license and getting the 30 semester hours, then he would need 2 years of apprenticeship. But since he's either obtained or about to obtain an associate degree, then he would only need 1 year of apprenticeship, 4 quarters.
We're discussing the timely presentation of the quarterly report. That's what's in question, correct? That's the only thing in question, whether or not he submitted his report. The 4th report.
Correct.
I think to boil it all down is we don't have it. He says that he submitted it, and what's going to happen? You know, what decisions the board are going to make. As I explained to Mr. Gamble, I don't have the authority to accept it now because it's beyond the 60 days. Because, as you'll recall, the board policy and the rule is that if it's not submitted, if it's not received, not submitted, but not received within board office within 60 days of the last date in which the credit is sought, then I'm to reject the report, send a letter back saying that it can't be accepted and there's no credit for that particular quarter.
Other report, excuse me, the other reports you sent in, did you send them registered mail or you just mailed them?
I just mailed them. I sent everything exactly the same way every time.
What's the date of the notary seal down there? I can't read it, but I take it that's.
October 10, 2012.
So it was notarized before it was supposedly sent on October. That the one in question? that
You have a
we-
copy of it,
Yes, ma'am.
Yes, there's a copy on your,
and it's a copy of the notarized document?
On the document that's missing?
Yes.
Yes.
we have a
I just
copy.
don't know that it got mailed, that's the question.
That's your question, yes.
Can I speak for a minute?
Sure, absolutely. State your name. for the
My name is
record.
Benjamin John Gamble. Me and my family have Holly Gamble Funeral Home in Clinton, Tennessee, and Lake City, Tennessee. Caleb came and spoke to me early in 2011, interested in the funeral service. I told him I recommended him do his apprenticeship prior to going to school, just to make sure he was really interested in the funeral business. Caleb has amazed me from the very beginning. He's got every paper that's ever got sent to him, from his very first registration for the application, the letters that the state sent him from the beginning. I made sure everything was on time. I remember signing off on everything. Our funeral home is a small firm. It's just me, my wife. We have one greeter, and Caleb. I know everything happened. I'm not trying to point any fingers at anything, but he's never been late on anything. I told him to start at a certain time in the fall of 2011. In the fall of 2012, his 1-year apprenticeship would be done. When he was done with school, his 2 years apprenticeship would be done. He'd be ready to take his state board, pass his national board, and pass his state law test, and he'd be ready to be licensed. And then when he called to get it arranged to take his law test, he found out that this one report was missing. And also be known that in his school, he graduated as valedictorian with a 4.0. He's never been late. I've been totally amazed by this boy, and that's the only reason that I'm here in front of you today, to stand good. This same thing happened to my sister. Her report got lost, but she's on the 10-year apprentice program, I believe. So we kind of let that go, but I have to say I know this happened. And I just asked the board, I've got proof of every funeral director and embalmer that's worked for me has signed a piece of paper that's saying Caleb did work his apprentice during this time. Everybody that worked for us knows that this happened. And again, I'm not trying to point a finger at anyone, but it seems to me there's just more proof here that Caleb did serve his apprenticeship than there is that he didn't. And maybe we can understand that something got lost somewhere, and maybe we shouldn't have to make him start a new quarterly report. There's just too many doors to me that seem like they're open for a mistake. Maybe when all this apprenticeship stuff starts, that the state should require that apprentices send their reports certified mail, or the state can send us back an email that verifies that they have properly got this file or this report, put it in their file, and it is stored in the right place. That way all this can be kept together, and if this does ever happen, the apprentice has some sort of proof that the state did receive it, and they have a receipt upon where it was received.
Mr. Ribble, does the office have any type of receipt mechanism in place?
Thought about this since Mr. Gamble and I have talked, and the best thing that I can come up with, Mr. President, is if the people, the apprentice, or the funeral home, whomever is sending it in, ultimately I think that, they both accept some responsibility for sending it in, but ultimately it's the apprentice's responsibility because that's the person who has the registration. And that won't help in this situation, but in future situations, I think the best thing to do would for them to send a self-addressed stamped envelope, and we could, after we stamp it as received, we can just merely mail the top copy back to them so that they would have that showing it received. They can send it certified mail, but that's this is what happens if you send it certified mail. Yes, the report was received, but was it complete and accurate? because sometimes we get reports that aren't signed by the supervisor, aren't signed by the apprentice, that the manner of death's not completed, or whether they assisted on the funeral or an embalming process. So even certified mail would show that a report was received. It doesn't necessarily show that a complete report that was accepted for filing was received. Because generally when we get a report, if it's not complete, then we mail it back to them, let them complete it, and send it back, and then as long as we get it within 60 days of the last day of the quarter, then we accept it. So that's for the people that that's the cheapest, most economic way, I think, is for them to send a self-addressed stamped envelope with it when they send their report in. And then we could make a copy of that, stamp it, and make a copy of the first page and send it back to them. We can send them an email, as Mr. Gamble suggested. However, sometimes there's problems with that. Sometimes their email address will change during the process that they're an apprentice, and we don't. If they put it on the report, then we have it. So we can do it one of those ways.
I think what you've recommended, that you returned a receipt to them in the self-addressed stamped envelope, is a good idea.
It wouldn't necessarily be a receipt, Miss Sally. It'd just
But
be
it
a
would
copy.
be
It'd be a copy of the first page
Well,
of
it
the
would
report.
be that received. and
Yeah,
blah, blah,
yes,
blah,
ma'am. Yeah,
stamped
he would
on it.
indicate that.
Yeah,
Yes,
that's what I mean.
yeah.
Mr. President?
Yes, sir.
Is this on? If you don't mind, I'd like to make a comment. I think I was with the board when we did these rules, and received means actual receipt by the board or the Department of Commerce and Insurance. So the question, I think, is not really whether or not he actually served it during that time, but whether or not he actually sent it and it was received. So even though we don't have a stamp on it, he could still stand before you and testify to you that he did mail it. And I mean, it's possible that the board received it even though we can't find a stamp. So, I mean, what I'm saying is the question is really whether or not he submitted that. And if he satisfies the board that he sent that, I think the board could still make a decision as to whether or not that was.
I think this young man's track record shows that he is reliable, and what he would testify to would be reliable,
But
as
if you
well
don't
as
have
his
any reason to
employer.
doubt it-
But my question is, there are people that are not as reliable as this young man, and would we be establishing a dangerous precedent? I'm all for this gentleman. But I just don't want to, I don't want to,
I want the witnesses to understand that the integrity of the witness is absolutely not in question.
I understand.
Where the board sits is moving on applications and apprentices that have been received by the board. And as Ms. Sowell has said, there's a precedent involved that we have to be careful with as well.
Add one more thing.
Yes, sir.
My understanding is that in this case, it's not as if they have a receipt and it's a week late. There's no receipt. So it's kind of like either you accept his testimony that he mailed it and allow an inference that it would have been received, or you're saying he just never sent it at all, which, if there's no reason to doubt his credibility, I think the board could take him at his word and just assume that a mistake could have happened when it was received here.
Are all apprenticeship forms notarized before they're sent in?
Yes.
Okay, is that one of the rules? I mean, they should be notarized.
Well, if it's not notarized, we take that as not being a complete form, and then we
Okay.
send it back to them
Okay.
for them to complete and send back to us.
So it's
or send us
standard,
an
it
email.
should be notarized then, okay.
There's a place on the form for it to be notarized.
Okay.
And again, I caution, there is, by no means do we need to discuss the credibility of a witness in a situation like this. We simply have to act upon what is before us in black and white is my feeble opinion.
When would you be next eligible to submit a report? This was the end of October, from October, November, December. So he could submit another report in January? Is that correct?
Well, it's a little bit more complicated than that, Miss Sally. His apprenticeship's, the 2 years has passed and it's completely expired. So if his apprenticeship is completely expired, see, it was effective August the 25th, 2011, so that expired the last day of August 2013. So that's the reason they came before you today. I don't have any way that I can remedy the situation. It's a decision that has to be made by the board, because we can't accept an apprenticeship quarterly reports on someone who has an expired apprentice registration.
So he would have to start all over again?
Not all over.
He'd have to resubmit
And that's
an
a decision
application.
for the board as to how you want to address that. What I'm saying is, as an administrator for the board, we can't accept a report from someone who has an expired registration. So even if, my only thing that I could recommend to Mr. Gamble at the time we had the conversation was that he re-register and serve whatever it is, two and a half months or whatever period of time it is. And then that's what Mr. Gamble said, but that defeats his purpose, because he thought he was finished and he wants to take his law test and get his funeral director and embalmer's license as soon as he can. So that's how we got to where we are here today.
Well, of course, the rules are the rules, but there's one thing that I do know, and stuff gets lost in the mail. And I believe, from what I've heard discussed here, that this board has the authority to accept that. And I know that we're setting a precedence on one situation, but based on the fact that he had sent the others, and you have the copy of the one that's missing. It was just not received in the office here for some unknown reason. I make a recommendation that this board accept the paperwork that was late or misfiled, or however you want to word it.
That's in the form of a motion.
That's in form of a motion.
Mr. Chairman,
Yes, ma'am.
question. Do we need him to submit to us either orally or in writing before we decide on this motion, a sworn statement that he did send this by U.S. mail?
We briefly look at the documents that we have on file.
I just want to.
Well, Mr. President, if he testifies that he did send it, and you accept that, and by the way, there's nobody saying he didn't send it, the board's just saying they can't find a receipt. So if you accept his testimony that he sent it, then you're not varying, you're not creating a precedent. I mean, you're sticking to the same rule, it's just you're finding through his testimony that he complied with it.
Do we need to have something in writing or as a sworn statement?
Well, this is,
In essence,
this is recorded, so.
Okay.
On this quarterly report that you received November the 26th, 2013, it's from 2012 then?
Yes, that was the day or after the day, a couple of days after Mr. Gamble and I had a conversation after he called me. I asked him to fax it. I don't remember if I asked him to fax it the first time we had a conversation. It might have been the second conversation.
Faxed a copy of what you had.
What he had kept, yeah.
See, with the apprentices never getting any kind of receipt that they were ever got at the state, they never know what's going on. They never know whether the first one was ever got, the second one, the third one, or the fourth one. You just kind of have to take for granted that
You
all
didn't
of them.
call and ask then.
No.
We're actually dealing with something that happened about a year and a half ago, correct?
Yes, he was under the impression it was all taken care of and it was all in his file, and he thought when he got out of school he'd take his law test, pass his national board, and be ready to get to work. At least that's what we were hoping.
You have a motion and a second.
No, ma'am, not yet.
Motion.
Hinkle made a motion to it.
Right.
You do not have a second?
So he the delay is part of the time that he was in school and did not actually apply for his license until he got out of school, correct? And that was when?
When I completed school,
Yes, sir.
that would be, I went through the graduation ceremony last Friday, and as soon as I take my national board exam, I will have the degree. That is the last requirement, is to sit for the national board exam.
Motion on the floor by Mr. Hinkle is to accept the apprentice report by testimony of the witness, and a copy of which has been presented, dated October the 10th, 2012. That's the motion on the floor. Yes, sir.
Second.
Motion has been made by Mr. Hinkle to approve the apprentice application, quarterly report application, to give the executive director permission to approve that. It has been seconded by Mrs. Sowell. Is there any other discussion?
I think every case has to be looked at on its own merits. I think in this case, as Mr. Hinkle said, we have the boy's been in school. We know that we did not receive it. I believe his integrity, after interviewing, speaks for itself, in my opinion. It was duly notarized. If somebody notarized that after the fact, that would be an illegal, their notary would be in jeopardy, which I can't imagine. I couldn't read who notarized it, but I would think the intent was there. If all the rest of them were sent in, then it's possibility, as counsel said, just that one fluke could have been the one. So I think we need to kind of look at this not as a precedent, but each individual case. The boy just graduated from school, was taking the national board. Did it say he has a 4-point average?
Victorian.
Yes, sir. Yes, sir.
Mr. Gribble, on page 2 of the letterhead, Department of Commerce and Insurance, near the top, are those 4 quarters of apprenticeship that were approved and granted? Am I misreading that? It's actually at the bottom. I think it says page 1, but it's, do you see where I'm on the letter? It is on the letterhead that was sent to Mr. Hamilton, I believe. Halfway down the page.
What page is it?
It's under this document, it's on the 4th page of the material that's been presented to us in a letter from Mr. Gribble to Mr. Hamilton.
Email to
Okay.
Dennis Hamilton.
Okay. Those 4 are there not 4 quarters that are addressed there?
There are 4 quarters of the address there. let me look back at the actual original. What happened, and the reason the email from Mr. Hamilton's in there is Mr. John Gamble, who serves on the board of funeral, as a director for the board of funeral, for the Tennessee Funeral Director Association. And Mr. Dennis Hamilton also serves as a director for the Tennessee Funeral Director Association. At some meeting or something, Mr. John talked to Dennis. Of course, Mr. Hamilton's a former chairman of this board, a past president of this board. So Mr. Hamilton inquired to me, as you'll see there in the email, and then that's when I answered him back as best I could, because I assumed that Mr. Hamilton would probably forward this information on to Mr. Gamble, Ben's father, John. And so I wanted to be as detailed as I could so he would have the information. The quarter, you do it on calendar quarters, but you're required to either have 1 year of apprenticeship or 2 years of apprenticeship, depending on which education level you have. So there are 4 quarters listed there, but that doesn't indicate a year's worth of apprenticeship. So he was approved on August the 25th, 2011. So that meant he would file a report for July through September 2011, but he would only include the cases that were on August the 25th through September the 30th. So it's a partial quarter. And then the others are full quarters, which the last one would have been for a partial quarter too, because he wasn't required to go all the way through September the 30th of 2012. It would have been for a partial quarter, and then that would make his full year up. It would actually be, even though it'd be 1 year of apprenticeship, there would actually be 5 reports that would be
Understand.
filed.
Okay, thanks for that clarity. So his apprenticeship would actually end August the 25th, 2012, would be 1 year apprenticeship.
Yes, sir.
Okay.
So basically, he's not a quarter shy, even, he's only
2 months or something like
a
that.
month and a half or something.
He's from, his life report would have been for July the 1st through August the 24th, actually. So 6 weeks, 7 weeks, something like that.
And this isn't in question today, obviously, but apprenticeship is 40-hour work week?
Yes. The apprentice is to be a bona fide employee working not less than 40 hours per week for the establishment.
Mr. Leach, you didn't log any work from August the 2nd to the 25th then, apparently.
Oh, sure. I didn't turn any, no, I didn't log it in the report, no.
Any further discussion?
Call for the question.
Ms. Mosley, remind us, the motion was made by Mr. Hinkle and seconded by Ms. Sowell, correct?
That's correct.
Okay. All in favor, say aye.
Aye.
Any opposed? Motion carries.
Thank you.
Good luck, young man.
Y'all have a blessed day.
Okay, the next one.
Mr. President,
Yes, sir.
finish that.
So, okay. Remember, I said there were 3 of these.
Yes.
Okay, today we're dealing with 2 of them. The other one has asked to wait and come into February board meeting. So Mr. Highsmith won't be dealing with that, but someone else that replaces him will be dealing with that. The last one, which is actually the where your records start on your iPad there,
First on earth.
is the first one, yes. It's Miss Jill, Corvin, Corvin. And she is from Johnson City, Tennessee, and she works at a funeral home up in Bristol, Tennessee, which Mr. Gamble and Mr. Lynch traveled a great distance, but it would be quite a bit further for her to travel here today. So she has asked that I present her conditions to you for a decision. Ms. Corvin was approved as an apprentice funeral director, apprentice embalmer, and a student effective August the 28th, 2013. That will be the letter that you see. You see that we approved it, and then we fax a copy of that letter to the funeral home. And also, because she needed to send her report in within 60 days, we asked one of the administrative assistants to call and verbally give her that information as well, as we do in all situations like that. Okay, let me cut to the chase of this one. We got this report on December the 3rd, 2013. The report would have been due November the 29th, 2013, which November the 29th was a state holiday. The weekend followed that. So as long as we would have gotten a report by Monday, December the 2nd, we would have taken it, stamped it, filed, put it in the file, end of discussion. But we got it one day later. It's just one day, but it's one day. So, if we have to be consistent from our side because we don't have any discretionary authority. So I write her the letter, we fax the letter to her, then she calls. And this part I want to make sure that you understand. She calls and she said, on Wednesday before Thanksgiving, I called the board office. I talked to one of the administrative assistants, and I was informed as long as I got my report there by Christmas, it would be fine. So in the course of the conversation, we do some research in her office and things like that, and I spoke with the person who talked to her. And the administrative assistant in her office said that she went and got her folder. She read the 2 sentences to her about what the rule requires, that they submit it in 60 days and that such a report must be received no later than 60 days, following a quarter for which credit is sought, and the failure to submit it will be cause for disapproval. But then the administrative assistant said that Ms. Corvin said, so what date would that be? And then the administrative assistant was trying to calculate it and calculated it incorrectly by 30 days. So we gave the lady some incorrect information. The rule's still the rule. We gave her, she had the written part. It's one day late.
It was only 1 day late anyway.
It's 1 day late.
1 day late only. And I understand, it's kind of like the guy before us here. You got the mail, you got this going. But Robert, y'all do a great job of doing this stuff for us. And it just amazes me when you deal as much as this and you're dealing with the Postal Service, and I'm not against the Postal Service, but I do know that, things drop by the wayside. And the fact that you got it 1 day late, it is late. There's no doubt about that. There was some issues with it. But I'm going to make a recommendation we approve this one.
Second.
Motion made by Mr. Hinkle, seconded by Mr. Starkey, for the executive director to administratively approve, well, actually, it's a board approval, of GLD Corvin's apprenticeship quarterly report as has been presented. Any further discussion? All in favor say aye.
Aye.
Any opposed? Motion carries.
And that concludes number 2 of 2, and the third one is still yet to come. And I readily admit these cases before you today are unusual situations. What I'm afraid will happen, though, is every apprentice that's late from now on will want to come and appear before you. And I would just urge the board, if there's not any unusual circumstances like there were in these 2 today, is to please don't approve them, because or if you change your mind and change the rule, because if you'll remember in November of last year, the board did a rulemaking process. Those rules haven't gone into effect yet. They're still being reviewed by the Attorney General's office. But what we have in this letter is word for word for what's in that rule. And I understand completely what you did today, and I couldn't do it, so I wanted to bring them to you for y'all to make a decision. I just don't want the apprentices to think we can go back to doing whatever we did, because you remember what kind of problem we had back before these rules went into effect, about they were waiting months to file their reports.
And that will be obvious, whoever's on the board in the coming months. There's four board members here tonight, or this afternoon. I thought it was gonna be nighttime I got here, and I just come from Kingston Springs. But, those issues, there'll be issues like this and other issues. And I think this board as a whole does a good job of looking at the individuals' paperwork and stuff and approving things that sometimes are just a little bit out of norm.
And that, when we reviewed that, this rule before, I'm trying to recall what the discussion was about the 60-day, having 60 days to file the quarterly report. And I personally have always felt that was entirely too long. If you put off and put off, you're gonna keep putting off.
Most of them send them in. What we tell them,
Timely.
what's a good thing to do is just remember by the 15th of the month, the following month after the quarter's over with, make sure you send it. That way it gives plenty of time for us to send it back if there's a problem. Of course, that's under the assumption that we're going to receive the report.
We need some action on what we discussed earlier about, can we authorize you to put into the applicant's instructions when they submit their quarterly report to include a self-addressed stamped envelope and a copy of whatever you want to send them will be returned to them, so they will know that it has been filed on a timely basis.
If they do that, we'll be glad to do that.
If you need a motion, Mr. Chairman, I will move to ask the administration to do that, and include that in
Would
the
that be in the-
instructions for the applicant.
Mr. Gribble, would that be in the form of a form letter when they initially make application?
We can put that in the
letter of
letter that we
instruction.
send back to them when we approve them, that if they want to do that. I want the board to realize that that's going to be somewhat time consuming.
That was my next question.
You know,
Do you
it's,
feel that would handicap or hamstring the board, the staff, the office in any way to do that?
We'll certainly be glad to do what the board wants done. It will, Ms. Mosby or Ms. Johnson, well, Ms. Mosby could speak more directly to it than, because she deals with it on a daily basis. Ms. Johnson deals in another area on a daily basis.
How impeding would it be for you if you had, this is the first page, first page of the application. It's stamped, the date that it's
We'll be
received.
glad to do it if that's what you want
If you put like
done.
a copy of that page and put it in a self-addressed stamped envelope that they've included.
Sure, we'd be glad to do whatever the board recommends.
Would that create a hardship for you all?
Any additional services that we present would, require more work. So, it would just be up to them. Everybody doesn't request it, so it might not be something that everybody would want. So,
Well, it would.
How many applications do
It's
you have a
preventative
month?
maintenance, though.
But what happens, we get these, like at the end of December 31st, we've got about 300, I think, that are active, somewhere in that neighborhood, 300 to 350. And we'll get most of those between January the 1st and January the 31st. Most of them will come in sometime during that month, during that time span.
Mr. President, what you all may want to do is make it so that if someone does include a self-addressed stamped envelope, then they can do it in that case. But if the person doesn't provide that with the with their quarterly report, then the board at that point shouldn't be responsible for
That's certainly
for
fair.
providing
Sure.
that copy.
And we could, guys, as board reports are given across the state through the state association, we could make people aware of that if you want to put a self-addressed envelope in with your quarterly report, that the office would return. Mr. Gribble, where is that mail actually open, those 300 quarterly reports? Is it actually received and opened in our office?
No, it's received by the mailroom and opened there, because if there's money there, then
And they are the one that stamps it received in that office?
No.
Okay.
It's in the mail room here within the building, and it's put in their box, and then we get that the same, pick it up the same day and stamp it received in their office. So it's actually stamped in their office. Now, sometimes if there's money in something, the Revenue Processing Center will stamp date. They will validate anything that has money on it. That not sometimes, but all times, they validate a date on there.
How many hands does this document go through before it gets to you all?
Goes
Received
from the
and
mail
dis-
room to
From the
us.
from the mail room.
From the mail room to us.
And then if there's money in it, it
No,
goes to
the-
somebody else.
Yeah, if there's money in it, it goes from the mail room to the Revenue Processing Center and then to the board.
And then to you all.
But if the quarterly report, there shouldn't be money in those, so they should come directly to us.
But they're still open there, and in case there is money in them. Anything, and I understand that because you've explained that to us before. And see, that could be, you could actually, with that much handling of the paperwork, you could lose something, or something could be a little, if I'm open mail today, and I got it all stacked up here, and I don't stamp it, and I go home this afternoon and I call in sick tomorrow and it's laying here and it finally gets in your box 2 or 3 days later, you stamp it the day it comes in your box.
But now there's procedures to take care of
I
that.
understand
Mr.
that.
Hinkle. They have more than one person in the mail room, so they shouldn't be stacked up. I can't, I don't handle, we can't stamp it till we get it, but there are procedures in place to reduce those
Yeah.
problems.
But I mean, it's not necessarily your office can't stamp it till they receive it. So somebody could actually, have access. The question that I'm going to ask is, other than 3 or 4 things that we've had before, and these 3, the system's working pretty good, isn't it?
It is. These are, to my knowledge, these are the first problems we've had in many, many months.
So I'm going to be the old grandpa, and I'm going to say, let's don't mess with the wheel that's rolling pretty good, okay? Right now.
Ms. Howell, do you wish to withdraw your motion, or does it need to fail for the lack of a second? You want to withdraw your motion? That was a motion, wasn't it, Ms. Mosby?
Yes, it was.
Okay.
Or if you want to do a motion where you would send the self-addressed stamped envelope back in.
Let me ask the board this. What if I just, in my letter of instruction that I make to the apprentice, if I just include a statement there, if you wish to receive a receipt for your filing, we'll figure out with the attorney how to word it. But basically, if you send a stamped self-addressed envelope, then we will send you a copy of the front showing it being received of the front page.
And you might state that in your letter, to ensure that you get properly credit, please, and you close this stamp addressed envelope,
So,
to
Ms.
ensure you get properly credit for your apprenticeship.
Ms. Sowell's motion fails for the lack of a second, so we will leave this matter to the executive director and his staff to deal with.
And, Mr. President, I'd request at this time if we could take a short break.
Recess for about 5 minutes, board.
I can find out how to get my air on here.
Approximately 12:09, continues on Tuesday, December the 10th, 2013. We return from our recess. The board meeting is back. Call the board back to order. The only items remaining on our agenda for today is the election of officers for 2014. And the chair will now entertain nominations for the president of this board for 2014.
Mr. Chairman, I nominate Mr. Robert Starkey, president for the term of 2014.
Second.
Mrs. Sowell places into nomination the name of Mr. Robert O. Bob Starkey as president of the Funeral Board for the 2014. There are numerous seconds. The chair will recognize Mrs. Taylor's second to that motion. Are there any other nominations to come before this board? Are there any other nominations to come before the board? Hearing none, all in favor of Mr. Robert O. Starkey serving as president of the Tennessee Board of Funeral Directors and Embalmers for the year 2014, let it be known by saying aye.
Aye.
The chair will now entertain a motion for the election of the vice president for the year 2014.
President, I nominate Miss Anita Taylor to the vice president position.
Second.
Mr. Neal places into nomination the name of Mrs. Anita Taylor for the vice president of the Board of Funeral Directors and Embalmers 2014. It has been seconded by Mr. Hinkle. Are there any other nominations to come before the floor? Are there any other nominations to come? Hearing none, all in favor of Mrs. Anita Taylor serving as vice president of the Funeral Director and Embalmers Board for 2014, let it be known by saying aye.
Aye.
Motion is approved. Congratulations to Mr. Starkey and to Mrs. Taylor. The chair will now appoint a continuing education liaison for the year 2014, and the president will ask Mrs. Jane Gray Sile if she will accept that appointment for the year 2014.
Yes, sir.
Are there any objections to that appointment? Mrs. Sile will be noted as the continuing education liaison for 2014. As we move to the conclusion of our meeting today, I want to take this opportunity to tell you that it has been a privilege to serve with the men and women of this board. It has certainly been a privilege to serve with the staff. Mr. Gribble, his professionalism and his integrity, in my opinion, is unmatched. Does an outstanding job, and I appreciate the relationship that I've had with Mr. Gribble for the past 4 years. Mrs. Mosby, you've been extremely helpful. You introduced us to iPads, got us all on our feet and up and running, and you were very patient with us. And we appreciate your patience and your cooperation through the last 4 years. Ms. Johnson, it's been a privilege to have you on board, and I know the board looks forward to a good relationship with you in the years to come. To our council, to Mr. Chick and Mr. McDonough, it's been a privilege to work with you guys as well. You do a good job in serving our board, and we appreciate that. I leave this board with mixed emotions. I feel that we have served effectively and efficiently. There are some issues that come about from time to time, laws and rules and regulations that obviously all of us aren't always 100% in agreement with, but that's why this board functions as it does. And I know that you will meet these challenges and these opportunities and these privileges in the year to come, and you'll do a good job. And I simply want to say thank you, and I want to say that you're in very capable hands under the leadership of Mr. Starkey. I know that he will do a good job. With that being said, yes.
This is my personal comment, but I think reflects all members of the board of how much we appreciate your professionalism, your professional ethics, and common sense, and practical application of the law, and to benefit everyone in funeral service, and primarily the consumer. We thank you for your service.
Thank you, Mrs. Sowell. With that being said, the chair will now call for a recess of this board, and we will reconvene at approximately 2 p.m. So we're now in recess. And we're dismissed.
For what?
We will now reconvene our Tennessee Board of Funeral Directors and Embalmers meeting, this being December the 10th, 2013. This is reconvening after our recess earlier in the day. Council?
Thank you, Mr. President. I believe at this time, Michael Driver would like to say a few words to the board.
Driver?
Well, thank you. My name is Michael Driver. I'm Chief Counsel here with the Regulatory Boards Division. I appreciate y'all sticking around and hanging with us today. I'm sure you're interested in what happened, and it went something like this. As we looked at the process and what we had with the emergency rules that came to our attention, there was some financial information regarding the fees in those rules that we really need before they're going forward. It's something we're going to be asked for every step, and frankly, we think it would be difficult to move forward before we have that. The plan is to get that together just as quickly as possible and look at the potential of you all doing potentially a teleconference if you can't get a quorum in person, or come back in to adopt those rules. It would be our recommendation as legal at this time for you all to consider putting those rules on hold until we can get that information and get it back to you, and then bring it back and let you all look at it so you all can make sure you're making the decision that you need to be making about those fees and those rules, and we can feel comfortable about how the process is going to move forward from there.
And this action, follow-up action, would need to take place before December 31st, is that correct?
That is absolutely correct, yeah.
Gentlemen, do you all have any questions or comments? At this point in time, I guess we would need to reconsider the action that we took this morning. Would that be the next step?
Or if you want to, I guess, reconsider it or put it on hold until such time as we can get that information for you.
We need to
yes.
rescind the action that we took this morning.
I think you could vote to essentially put it on hold without actually rescinding the action. You may end up voting to support that later. And so I don't think a rescission is technically necessary. We're just asking that you hold off essentially until we can get this information together, which hopefully will be it will be as speedy of a process as we can make it.
Then if new figures were announced or decided upon later, we'd work out the legal technicalities on that in addition to what we did this morning.
That's correct.
Okay. Any comments or questions, gentlemen? Mr. Gribble, do you have any comment? Mr. McDonald?
Mr. Driver, with a motion to hold the emergency rules pending further financial data, would that be a sufficient motion if the board decided to do that?
That sounds perfect, Mr. Gribble.
Make a motion.
Second.
The motion has been made by Mr. Starkey and seconded by Mr. Hinkle. And Mr. Gribble, would you state that terminology again, please?
Motion to hold emergency rules pending further financial data.
That motion is made by Mr. Starkey and seconded by Mr. Hinkle. Is there any further discussion? All in favor of the motion, say aye.
Aye.
Any opposed? Motion carries. Is there any other business to come before this board, gentlemen?
I have none, Mr. President.
Gribble?
No, sir, thank you.
The chair will entertain a motion to adjourn.
Make a motion, we adjourn.
Motion made by Mr. Neal, seconded by Mr. Starkey to adjourn. All in favor, say aye.
Aye.
Motion adjourned. Thank you.
And coming back at 4:30, I know that was an imposition to